Should BotSentinel be complying with GDPR? And is it possible that BotSentinel is in breach of GDPR? That's what I'm talking about in this video, so welcome back. I am the Black Belt Barrister, helping you to understand law. So lots of you have tagged me with this question, you've messaged me with this question and pointed me towards videos talking about this very question. So I thought I would go over a very broad overview of GDPR, what it means and what it might mean for BotSentinel, and whether there might in fact be a breach of GDPR in this instance. And just as a heads up, this video is at least partly sponsored by NordVPN, more about them later. For those of you thinking what on earth is GDPR, well, it is the General Data Protection Regulation. It's a European Union law which has quite a wide and broad effect and protection for personal data. What is personal data and what is the scope of this? These are the things that we're going to look at in this video. Well, GDPR took effect on May the 25th of 2018, along with the Data Protection Act of 2018 for England and Wales. But of course, that was pre-Brexit, and now we are post-Brexit. We have the retained GDPR in the United Kingdom. But as I'm going to discuss, GDPR has far more reach than simply in England and Wales, and indeed the United Kingdom. To put it very broadly, GDPR was brought about and codified to protect the rights of data subjects and their respective personal data. Not to be confused with the citizens of the EU, because that's something I'll come back to in a moment. So what we're really talking about is the personal data of the data subject in question and protecting the rights and freedoms of those data subjects. The pressure to bring about change was from the vast increase on the amount of data and communication of that data via technology, via the internet predominantly, and various other means, globally and not just within the EU. With such a vast increase on how data has been collected, transmitted, stored, manipulated, and disseminated, i.e. passed on to other people, there was a need to protect the fundamental rights of each individual, particularly, of course, with respect to privacy. Now, whilst as a caveat, this video cannot be seen as legal advice, but it will be a fairly broad overview, and certainly not in any huge amount of detail, despite the length that the video might end up being, because GDPR courses can themselves span several days to learn everything you need to know about GDPR if you are caught by the data protection regulations. Notably, of course, with the territorial scope of GDPR, which is one of the reasons I've been asked to comment on this very issue. Now, whilst GDPR is directly applicable to all EU member states, and as I've said, the UK has a retained version of GDPR, it is also very important for you all to know that non-EU companies also get caught by GDPR. Because if their controllers are processing data of data subjects who are in the EU, they are caught by the regulations and therefore also subject to enforcement. So there are several articles and recitals within GDPR which tell you pretty much everything you need to know. I will link those in the description below. But the very broad one is Article 3 of GDPR, which provides the scope effectively of when GDPR applies to controllers and processors of such data, defining both when it applies and to whom it applies. Article 3 is aptly titled Territorial Scope. Part 1 provides that the regulation applies to the processing of personal data in the context of activities of an establishment of a controller or a processor in the Union, regardless of whether the processing takes place in the Union or not. In other words, the controller might be in the Union, but the processing takes place elsewhere. The territorial scope means that they are still caught. Moving on. Section 2 provides that the regulation applies to the processing of personal data of subjects, remember, not necessarily citizens, but subjects who are in the Union by a controller or processor not established in the Union, where the processing activities are related to the following. So before moving on to that, this means that a controller or a processor who is not established in the Union, i.e. they're established elsewhere, processing the following activities, these regulations do indeed apply. These activities include offering of goods or services, irrespective of whether payment of the data subject is required. In other words, the services could be free or even the goods could be free to such data subjects in the Union. So such a service could be offered to a data subject within the Union free of charge by somebody outside of the Union. These regulations apply. But Part B has another meaning. The monitoring of their behavior as far as their behavior takes place within the union. So if a data subject is within the union and is behaving in a certain way, let's say using Twitter, for example, as in the case of BotSentinel monitoring Twitter accounts, the behavior of somebody using Twitter could be monitored when that user's activity is taking place within the union. So, reading back again for clarity, the regulation applies to the processing of personal data of data subjects who are in the union by a controller who is outside of the union, where the processing activities relate to either goods or services, whether free or otherwise, or the monitoring of behavior that takes place within the union. Then Part 3 of Article 3 quite neatly rounds this off to say this regulation applies to the processing of personal data by a controller not established in the union, but in a place where member state law applies by virtue of public international law. Now, I've talked many times about law applying internationally. To some degree, this relies on cooperation between jurisdictions, but history has told us that on many of those occasions, indeed, there is cooperation internationally between jurisdictions to uphold what is seen to be good law. And as I mentioned earlier, a very brief word on my sponsor who helps to keep my channel going, NordVPN. Many of you may have heard the term VPN before and not know what a VPN is. It's a virtual private network, meaning when you connect your computer to the internet, the VPN helps you to create essentially a private network even though you are on the internet. And what that really means in practice is that it will encrypt and keep private all of your internet browsing and traffic, particularly any sensitive details such as your logins and your bank details that you don't want other people to be snooping on and to read whilst they're in transit across the internet. Not only that, there are new features coming out all of the time, such as NordVPN's threat protection and dark web monitor, meaning it can scour the internet to search for any bits of your data that might have been leaked anywhere online and alert you to that fact. Plus, when you're browsing websites, it can tell you whether the website is malicious or whether there's any malicious scripts or software when you're trying to download files. On top of that, if you want to watch any TV programs on any streaming service that are based abroad, maybe you're living abroad or you just want to expand your library somewhat and they're not available in your jurisdiction, you can remotely change or virtually change your location so that you can watch these services that would otherwise only be available in another country. As I've said to you before, I use NordVPN myself. I pay for it myself and have done for over 2 years now. I use it on all of my devices. It is a one-click connect on every device, my phones, my iPads, my laptops, you name it. It's a one-click connect and it's seamless and very fast. It doesn't interrupt the flow of my work and it doesn't slow down my internet connection. If you want to try this out, you get a money-back period, plus you get a unique discount by signing up with the link that's on screen right now and in the description below, which is very simple. It's nordvpn.com/blackbelt. That's how you know it's an official link. It's my unique link to give you a unique discount that you can sign up for right now. I believe once that you've installed this and you run it and you have that peace of mind that your data is encrypted, your connection is secure and encrypted, there are no logs, there's no tracking. NordVPN does not retain your data and track your data any more than you want Nord to check the dark web to see whether your data has escaped anywhere and alert you to that fact. Otherwise, there are no logs at all. There's no tracking of your activity online. It's all very secure. So as I say, this link is unique. You get a 4-month bonus if you sign up using my link. You get 30 days within which you can change your mind and cancel for a refund. But above all else, NordVPN will ensure that your connection is secure and protected from all of the modern new online threats. So check it out. Thank you for giving me the time to thank my sponsor. And now back to the video. Now, as with any piece of law, there's often another bit of law which explains what that certain bit means and how to interpret it, such as in the case of monitoring behavior, which remember came within this Article 3, we can look to recital 24 because this goes into a little bit more depth in whether to determine whether processing is an activity that is considered to be monitoring behavior. Reading from Recital 24, it provides that the processing of personal data of data subjects who are in the Union by a controller or processor not established in the Union should also be subject to this regulation when it is related to the monitoring of the behaviour of such data subjects insofar as their behaviour takes place within the Union. That's the bit where Article 3 applies. Underneath, it gives a little bit more explanation in whether to determine whether that is monitoring behaviour or not. It provides that in order to determine whether a processing activity can be considered to monitor the behaviour of data subjects, it should be ascertained whether natural persons are tracked on the internet, including potential subsequent use of personal data processing techniques, which consist of profiling a natural person, particularly in order to take decisions concerning her or him, or for analysing or predicting her or his personal preferences, behaviours, and attitudes. Now, it's the particular wording within this section that makes this very interesting and makes it very likely that BotSentinel's activity is going to be caught by GDPR. Because tracking the activity of internet users who are data subjects within the Union, when tracking of such activity is using certain techniques, tracking their internet activity, which is profiling these people, and particularly in order to analyse or predict personal preferences, behaviours or attitudes. When looking at the scope on BotSentinel, it is certainly profiling individual accounts, many of which will be within the Union, and it's categorising them as normal, satisfactory, disruptive or problematic. Now, upon my reading of Recital 24 in GDPR, remember this is just my opinion and it's not legal advice, but my reading of Recital 24 is that this processing activity of these accounts, and presumably in the background processing the tweets and the words and the nature of the retweets or the general nature of the content itself, in my view, falls to be a processing activity which under Recital 24 is monitoring the behaviour of data subjects in order to profile or analyse or predict personal preferences, behaviours and attitudes. If nothing else, those few words qualify the monitoring of said behaviour. So what does this mean for BotSentinel, and does this mean that there is any potential breach of GDPR? Well, first of all, getting a few of the exceptions out of the way. There is one such exception which is known as a household exception. So if it is simply for someone's own personal use, then that is outside of the scope of GDPR, but that is clearly not the case here. Other exemptions known as national derogations include things such as national security, defence and public security, public health, social security, judicial independence and investigations, and so on and so forth. Unless I am very much mistaken, I don't think BotSentinel is engaging in any of those, so none of those apply either. But taking a quick look at the relevant data itself that's in question and whether it does bring into scope these data subjects within the Union in accordance with GDPR, GDPR really defines personal data as any information that relates to a data subject. This is in Article 4 of GDPR. In which the subject is identified or identifiable as a person to whom that data belongs. And as to the question whether or not the person can be identified, the person can be identified either directly or indirectly by any kind of identifier, such as their name, an ID number, a username, location data, IP addresses, profiles, biographies, or any other information that can identify, whether by itself or together with any other information, that individual and therefore engage GDPR. Anyone signing up to and using Twitter is clearly under the scope of their privacy policies and under their jurisdiction for GDPR. Twitter will obviously have its own data protection department, data controllers, people in charge of data processing, and so on. But of course, that doesn't provide anyone else the right, or indeed any exception from the scope of GDPR, simply by using information that is posted to or on Twitter. Then we come on to the data processing itself, going back through this analysis process. Well, data processing, assuming that it's a data subject and it's data that could be by itself or together with something else, identify that individual. Data processing is extremely broad and could be anything to do with collection, recording, organizing, structuring, storing, adapting, altering, any kind of use, dissemination, analysis, even its erasure or destruction. And so assuming all of these are true, which in my view they are for anyone that is storing and using information in this way, there needs to be a lawful purpose for the processing of the data, there needs to be fairness and transparency, and there needs to be purpose limitation, which is broadly defined as only collecting the information needed for the purpose that it was collected for, and no further processing than is necessary, and no further processing beyond the scope of the lawfulness of that collection in the first place. So in this case, let's look at the lawfulness first. There are a number of ways that processing of data could be lawful. One of the most common ones is signing up to terms and conditions or signing a contract with the data controller. This is known as performing a contract with the data subject. This is under Article 6(1)(b) of GDPR. There are various others, such as complying with a legal obligation, could be to protect the interests of a data subject. This is usually a fairly broad scope, like an epidemic or processing for humanitarian emergencies, for example. Also performing tasks that are carried out in the public interest or in the exercise of an official authority. And another one that a lot of data controllers fall back on is the data subject consents to the personal data collection and processing. This is Article 6(1)(a). However, relying on consent was something that a lot of businesses fell foul of, because GDPR requires consent freely given in an informed situation unambiguously by the data subject. For example, it would be no good to have a pre-checked box on a form because the user has not checked that box themselves, so it had to be an unchecked box and the user would have to check that box to provide consent to collecting and processing their data. But either way, it had to be a clear and affirmative action by the user signifying their agreement to the collection and processing of their personal data. Consent should be freely given and, of course, can be withdrawn at any time. In other words, to be clear, the data subject whose data has been collected has a right to withdraw their consent at any time to their data being collected, stored, processed, and so on. Now, many people might by this point be saying, well, the information, the tweets, the usernames, the biographies, and everything else are already available on Twitter. So if a website is simply collating that information, surely they're not doing anything wrong. This comes under the very broad heading of data obtained from third parties. Because if data is obtained from third parties, then the controller, for the new third-party controller, must also provide the same data subjects with the same information required by the original controller, in this example, Twitter, that collected the information in the first place. So suffice to say, the simple fact that the personal data might already be publicly available does not mean that GDPR does not apply. Some people refer to this as the public domain and think that because personal data is in the public domain that it can be freely used without complying with GDPR. That's not true. There isn't really such a thing as public domain. There's information being on a platform such as Twitter, and Twitter have their own obligations for GDPR, as does anyone else or any other company that uses that information for any ongoing processes. Article 14 of GDPR makes this quite clear, in that certain information is to be provided to the data subject where personal data has not been obtained from the data subject. In other words, it might be taken from another company or from a publicly accessible source. And at the outset, it provides that where personal data has not been obtained from the data subject, the controller shall provide the data subject with the following information. And this includes the identity and the contact details of the controller, and where applicable, the controller's representative, other contact details for the data protection officer, which is required under GDPR if data processing occurs, the purposes for the processing, the categories for the personal data, the recipients or the categories of recipients for personal data, and a lot of other things. Now, some of these are not required if, for example, the data subject already has the information, which in the case of a tweet might well be the case because the data subject might well still have a copy of that tweet or has easy access to it. However, that doesn't extend to further processing and profiling, such as monitoring the behavior and then assigning a certain category for that person. If that person is not told about that and they are profiled and monitored and further processing occurs of that publicly accessible information and the data subject is not told about it, then in my view this would be a breach of GDPR. There are some other exceptions, such as whether it would be disproportionate to provide the data subject with that information, but that is balanced firmly against the rights of that data subject as to how their data is being used, processed, and how any further monitoring or decisions or profiling happens thereafter. Now, very briefly before I wind up, where GDPR applies, the data subject to whom it applies have various rights, known as an information right, a personal data access right, personal data rectification rights. All of these revolve around rights to access the information, be told about what the information is and how it's been processed, the rights to get it rectified, the right to have it erased and deleted. This is often referred to as the right to be forgotten, rights to have the data processing restricted or objected to, or all sorts of things. Again, I'll put a link to some useful guidance in the description down below. And suffice to say, if there were a breach of GDPR, there can be some heavy fines, which might rely on international cooperation if the relevant authorities would decide to step in and issue fines if they found there was a breach of GDPR by any company, regardless, as I said, whether they are in the union or not. So I hope you found that a very useful guide and overview. Thank you for letting me thank my sponsor. Please do like the video, remember to subscribe, and as always, thank you for watching.